Can you hear us? Anyone? No? Maybe? Yay, thank you all. We are waiting for Professor Chianti. So just bear with us. It's still early. Also, for anybody that's online, we did bring, and I cannot stress this enough, unofficial practice tests that are available in the library. I can also email them to you, or to email to you, just respond in Teams or shoot me an email, which should be on the flyer. So, let you know.
It's a 3-hour class. It's a first.
That terrible scar. Are you planning on Monday?
Yes. Yeah, I think, even with.
Really? Oh, well, I guess you could do a lot of different.
Yeah.
Yeah.
Applebee's is a.
And they're moving.
Yeah.
They're making a comeback. They're actually gonna renovate the places. That Ruby Tuesdays, TGIS, they suffered.
Yeah.
Because the sports bar started beating them up. They were before. Remember?
Yeah, yeah.
Then these sports bars of all the TVs started eating them. So it's bad. I think it's bad. But the food's better. They concentrated on the people.
Yeah.
And this is
Pretty
convenient.
quietly.
It's right up the road. Even that, I
I would like,
they still hang out the crayons and stuff for the kids, right?
yeah.
Yeah.
There is a online study guide through the library website on a regular basis, and there's 2 other practice tests there, and it'll score and tell you, and then it'll explain why the answers are right or wrong. And I don't know that information.
No, sure. I found this. I remember I think the last time I emailed you, you have a link, or I'm sorry, before I joined the program that I was in, she sent like, I'm not sure if you know, it's Letitia,
Letitia.
she does like, if you're missing whatever requirements for your, pre-graduation stuff, she'd say, oh, you're missing this, and she sent me like some
She's
stuff.
an advisor.
She is, I remember her from actually, like,
Lake Worth or here?
Elementary school.
Lake Worth.
her daughter and I were like really close friends, elementary school, so
She's
I'm
a-
like, me.
That's awesome.
But she sent like a link and, I found last night, she sent, like a link, I think probably what you're talking about, and I'm like, oh,
Metrics.
I don't know, I haven't on it.
Okay,
But it was through the databases, and I'm like,
that
oh,
might be it.
I didn't even, I'm like, oh, I didn't know that. That's the email paper.
Because the metrics also does, I mean, it's got HESI and ACT and EMT.
Still, just in case it's not, I can still take it if you send it or however you do. Just in case I don't have it.
Good afternoon. Can you hear me? Good afternoon.
Yeah, it's on.
Please respond on Teams or over the microphone, we should be able to hear you
Anybody there?
or something.
Danielle, you getting anything?
No. Yes, I can hear you.
Yes, okay.
Thank you, Akoya.
Thank you.
All right, everybody. Today, we're gonna finish up competency C and D, or parts 3 and 4, if you want to refer to them that way. We're picking up where we left off on Monday. Again, Danielle's gonna type my email in chat. If you want the link to this recording or any other documents, I have the 27 amendments. I have the US Constitution in separate PowerPoints. The amendments will be very helpful. All 27 in one PowerPoint. So if you need that, please. Of course, you can always Google that online. But having it isolated in a document, probably more helpful. All right. So these are the documents that have shaped the nature and functions of our institutions. They're supposed to. Starting with the Declaration of Independence. So I'm going to go through a series of documents, why they influenced the founding fathers, basically in developing the system of government, which operates under the United States Constitution. So they had to draw back to other documents, and in the past. And of course, the Declaration itself will be used as a source, but Thomas Jefferson will use other sources to write the Declaration. But the Declaration, taking a look at it itself, it basically is declared because there's a lack of representation in the colonies in Great Britain. This is basically a letter to King George III. This is a letter to the monarch. explaining all the grievances that the colonists have, starting with unfair tax policies. Having to quarter British troops. Quarter means you give food and lodge to British troops. Imagine having dinner one night, they're knocking on your door, and there's two soldiers standing outside saying, thank you. We'll take that and we'll take that room. That's what quartering is. It's also, will be put into the Amendment 3 in our Bill of Rights. They take the ideas, remember the Enlightenment from Monday. I mentioned the Enlightenment, the Age of Reason. They also, the Declaration is divided into 5 sections. And in the end, basically provides justification for a revolution. You might be asked the question, who is Thomas Jefferson referring to in the Declaration? This letter, what its intent is to declare to King George III, these are the problems he caused. George III might have that question. Who is he addressing the Declaration to? King George III. This is a definitive statement that Americans do not want kings or dictators or a government with too much power. Once again, our friend, John Locke, he was mentioned in the other session, session 1, and the social contract. Like the fact that this is repeated so that you can retain the information. He also wrote 2 treaties. Treaties is like a short essay on government. That all humans have natural rights. The government is required to protect. If government fails, people have the right to overthrow. You see how Jefferson refers to John Locke. Right? In the Declaration, he's saying, well, this is to you, King. You're doing this, this, and that, and we have a right to be independent. Social contract again. And this is a kind of simplified definition over here. Give up some rights in order to be protected by the government. It represents the will of the people. So we're supposed to be in that social contract with our government too. All right, so that's the Declaration. Other documents. Oh,
Oh, they do it again?
yeah.
Uh,
Give me 1 second. These is,
I think because
yeah. The Magna Carta, that was on the test. Couple of dates. Magna Carta 1215. 1215. England. Signed by King John. King John would be the first monarch to be challenged by his nobles and have his power limited. And if you look under Magna Carta, this think about what you're reading here, how it refers to what it's supposed to refer to us today. Limiting the power of the executive branch is the same thing as limiting the power of the king, right? The first document that establishes a rule of law. King John has to acknowledge individual rights of citizens, due process, and property rights. This is written in 1215. It's 2026. And we are supposed to have these protections today. Another document that our founding fathers referred to is the English Bill of Rights. Protection of natural rights. The right to petition a government. We're supposed to, under law, have the right to petition as well. And once again, the second treaties of government. Treaties of government is basically John Locke's social contract and limiting the power of government. Government derives its power through the consent of the governed. So we have with the Magna Carta, limiting the power of the king or limiting the power of the executive. No one is above the law. Rule of law, protection of individual rights, due process, property rights. All that's Magna Carta, English Bill of Rights, John Locke's social contract theory. Ideals that are included. Once again, yes, this is repetitive. Natural rights, protection of inalienable rights. Make sure you understand what the word inalienable means. Sometimes, and it's correct both ways, it will be spelled unalienable or inalienable. It's the same thing. It means cannot be taken away. Natural rights, ideal, popular sovereignty. Again, I mentioned on Monday, we'll see that a lot. Popular sovereignty, power of the government derives from the people. Rule of law. I'm sure many of you, if not most of you, all of you have studied the civil rights movement in the United States. Beginning at the World War II to the 1950s and 1960s. Well, if you're wondering why that was possible, is because the principles of equality, going back to these documents and these ideals and these principles. Look back to Dr. King. All people, regardless of gender, race, or any other category, are created equally and deserve of equal treatment. That was his message. Every once in a while, that message gets lost on certain leaders that are elected. They have to be reminded. As old as these ideals are, they're going back almost 400 years. Magna Carta even further. All men are created equal. That's expanded over time to amendments and Supreme Court rulings. The thing is, these principles and ideals are only good if the elected officials comply. And we citizens have to remind them. So there it is. There's the justification. This validates the Declaration of Independence. Believe it or not, and could be a question. I saw it on one of the tests I took. What is the oldest written constitution in effect today? You might get tripped, stumped, and say U.S. No, it's the Constitution of Massachusetts actually is older. Written by John Adams. A couple of extra notes on John Adams, okay? He will be George Washington's vice president. John Adams is also the second president of the United States. There are some history questions, so I'm going to try to add those as we go along. Second president, he's also the first president to live in the executive mansion / White House. It was not called the White House till later. It was first known as the executive mansion. Teddy Roosevelt, when he was president in the early 20th century, had the house repainted. And he painted it a bright white, and that's why it got its nickname. John Adams. So Adams himself, influenced by the Enlightenment in the Massachusetts Constitution. 1780s of data on that. In the Massachusetts Constitution, there's separation of powers, 3 branches. I grew up in Connecticut, familiar with Massachusetts. Massachusetts, its state government is divided into, well, the governor, and it has its House and state senators, and it has a Massachusetts Supreme Court. In fact, most states follow that pattern, if not all. Before the US Constitution, there was a governing document known as the Articles of Confederation. That was on both tests. Articles of Confederation were in effect from 1781 to 1789. They got just follow me here. You had a governing body during the American Revolution known as the Continental Congress. In 1781, that Continental Congress devised the Articles of Confederation. Basically a blueprint of how, when the United States achieved independence, how the United States would be governed. Divided by the Constitutional Congress. Continental Congress, sorry, continental. So you might be asked a question on the test, or I don't remember how exactly how to phrase. Basically, what preceded the United States Constitution, and your response would be the Articles of Confederation. This is the in-between. It provided a framework and a guideline. Basically, the 13 states acted independently would come together for a common defense. The problem with the Articles of Confederation, and this could be a possible question on the test, there are weaknesses. It created a loose confederation unified for defense and mutual cooperation. There it is. If you want to take something down, it's underneath on this slide. The intellectual influences of the articles. Take those down. First Constitution of the United States created a loose confederation unified for defense and mutual cooperation. Unicameral. Know what that means? There was a question on the test. Which one of these terms means one House legislature, 2 House legislature? That kind of question. Unicameral means 1 House. Bicameral means 2. We have a bicameral Congress today. House of Representatives and the Senate.
And one of the houses just passed daylight savings time.
It's gonna stay.
They passed the House.
That's how it's gotta pass. See, the man just mentioned that the permanent daylight savings passed the House of Representatives
Last night.
last night. Still needs to pass the Senate. If it passes the Senate, then it goes to the president. He decides to sign it, it becomes law. If he vetoes it, the bill still has a chance. If the House and Senate get 66% of the vote, they override the president's veto. Now, what I just explained is known as a check and balance. Daylight savings right now. Actually, Benjamin Franklin. Oh, A side note, if you're taking notes, you're listening. It was Ben Franklin who came up with the concept to help farmers and give them extra planting and harvesting time.
That was the reason I didn't know it was better.
Yeah. It was for farmers. Longer time, longer days so they can plant and a longer day so they can harvest and then it would go back.
So we can blame Ben Franklin for daylight savings then.
Yeah.
Blame him.
Yeah.
Yeah, because it's like useless, I guess, because we're not farmers. We're
Create a loose confederation. A unicameral, central
not,
government with limited powers.
Okay.
Yeah, 1 second, we have we have a question here, I'll get to.
But it lacks the authority to tax Grand Army.
And that's part of it, we're gonna get to its weaknesses, the articles, because by 1787, the founding fathers, the leaders of all the states are gonna realize this is weak. We're vulnerable. And we don't have the power to raise an army because we don't have the power to tax. What they're gonna need to do is count on each individual state to provide a state militia. So what happens if you get attacked by France or Great Britain or Spain? We're without a paddle. Okay? You understand what I mean? Never say no. But here's the problem. Revolution, the Declaration of Independence leads to a revolution. We're trying to get rid of a tyrannical monarch government, right? So their fear is that they'll set up a government just like that. But what they did was they went totally in the other direction and created something so weak, left themselves vulnerable. Totally limited the government. We'll get back to that. Theories that shape the articles, but I want you to focus on here, the weaknesses of the articles. One vote didn't have the authority to raise an army, didn't have the power to levy taxes, relied on states to provide militias. States could ignore it. No central authority. No executive, no judiciary branch to resolve disputes. And if they had any legislation, aside from what they couldn't do, you had to have a unanimous agreement. That's not practical. It's not going to function. Imagine today, they have written the Constitution so that every single member of the House and every single senator has to agree in order for a bill to pass. It's impossible.
That'd be fun.
And there was an inability to make changes necessary to establish a fully functioning and effective system of government. I don't have it on the PowerPoint, but there's a couple of key reasons why there will be a need to either strengthen the articles or scrap it and start over. I want you to write down 1786, Shay's Rebellion. Shay, Daniel Shay, Shay. 1786, Daniel Shays gathered together basically farmers who were protesting a tax in the state of Massachusetts. Now they proceeded to march on the Capitol, Boston. And they were almost successful. Thankfully, the Massachusetts state militia stayed loyal to the state government and squashed the rebellion. So the rebellion squashed, but Shay's Rebellion puts fear into the other 12 governors and all the leaders. Under the Articles of Confederation. And they decide to have a meeting in Philadelphia in 1787. There could be a question on the test about why 55 delegates met in Philadelphia to write what would be the United States Constitution. The weaknesses of the Articles and Shays' Rebellion, the effect of Shays' Rebellion.
Were they scared? The other governors were scared because their militia might not have been.
Exactly. The other governors, yes, they did not want chaos because the whole experiment could have went down the drain. So they knew they had to keep it together. This was a young nation, very vulnerable. Didn't have the army that we know today, the strongest army on earth and the strongest navy on earth. But we're nowhere even near there. So coming together and making it right was very important. That's why, due to the weaknesses of the Articles and Shays' Rebellion, it would be necessary to meet in Philadelphia. Now, they initially meant to fix it, and then decided to just scrap it and start over. And thankfully, they didn't. But there was some positive legislation under the Articles of Confederation. They're known as the Northwest Ordinance. Okay? I wouldn't worry about the Northwest Ordinance of 1784. It's these two right here. All right. There was a question on these two. So if there's anything positive about the Articles of Confederation and any legislation that was passed under it, it's these two. First, the Northwest Ordinance of 1785. As seen from the map, settlers are moving into these areas, and there needs to be a system in which townships are laid out. 1785, the Northwest Ordinance of 1785 is very specific about townships being divided into 36 sections, areas set aside for public schools, and allocating land for the military. If you travel, or any of you from, or any, if any of you are you from Ohio, Indiana, Illinois, Michigan, and Wisconsin, basically their townships laid out the same because of this. To this day, I mean, obviously there have been changes, but the problem is, if you drove, which I've done, drove through these areas, you noticed similar patterns. I was looking for it because of the history. But yeah, very much how it was laid out. And then 2 years later, there's a most influential piece of legislation under the Articles. It's definitely the Ordinance of 1787. It defines how new territories will become states, a process of dividing again a grid of townships, a path to statehood. This is significant. This will affect the American West. All those big states out west will follow this. And this piece of legislation will also be incorporated under the United States Constitution. It remained probably one of the only things they took. 60,000. When a population reached 60,000, they would be admitted to the United States if they so chose. And they would be on equal footing with the original 13. That's big. Okay. So Ohio, Indiana, Illinois, Michigan, Wisconsin, all came in eventually under this process. And they would have equal footing with the original 13. Now, what I have highlighted in green and gold, that would also carry over. Bill of Rights, habeas corpus, trial by jury, religious freedom. The biggie, prohibition of slavery. And so as early as 1787, northern states begin to outlaw slavery, and the new ones never had it. Ohio never had slavery. Kind of as a territory, but it won't as a state. Ohio, Indiana, Illinois, Michigan, Wisconsin start out as states that prohibited slavery from the very start. And as it says at the bottom, this was groundbreaking for the time. I mentioned in session on Monday about James Madison. I mentioned the Federalist Papers. This will also influence the United States Constitution. It's a series of essays promoting a powerful central government and the fact that the Articles of Confederation need to be scrapped. It also promotes separation of powers, checks and balances. Principal authors, there are three. I will come back to the slide. Alexander Hamilton, James Madison, and John Jay. Remember that James Madison's a tricky character. You're going to have to, if you're going to study him. He actually promotes. He's a Federalist. He's on board with Alexander Hamilton. If you remember from Monday, I mentioned this. He will later disagree with Hamilton over the National Bank, then become a anti-federalist or Democratic Republican. So Madison plays both sides of the fence. Keep that in mind. And if there's a question on Madison, know his biography as well. Madison is a Federalist who will turn anti-Federalist or Democratic Republican. James Madison is known as the father of the Constitution. That was a question on one of the tests I took. Who is known as the father of the Constitution? James Madison is the author of the first 10 amendments known as the Bill of Rights. That wasn't fun. One of the easier questions on the test, I hope all of you have that one, was what are the Bill of Rights also known as? Or what are the 10 amendments also known as? That was the question, sorry. Question I remember was, what are the 10 amendments also known as? Bill of Rights, first 10. I was on Madison, right? Right? Yeah, all right, so you have Federalist, term, anti-Federalist, Democratic Republican. Father of the Constitution. Fourth President of the United States. Fourth. James Madison also led the country during the War of 1812. War of 1812 was basically a second conflict with Great Britain. Second conflict with Great Britain. They were being particularly obnoxious after the American Revolution.
Here, I wonder why. After the steel day too, right?
Yes. Oh, yeah, Bastille Day was today, yesterday. A couple of historical with James Madison too, while we're on the topic, side notes if you want to take. The country's national anthem was written during the War of 1812, the Star Spangled Banner. Some of the questions would hit me by surprise, but luckily because of the history background, I was able to. So I'm trying to remember the best I can to help you. Remember, your focus is to get 48 out of 80. Develop a strategy. If your strength, when you're studying the 4 competencies, if you're strong in 3 of the 4, that's 60 questions you get. Correct. And 60 out of 80 is a 75%. That's more than what you need. So you kind of want to be strategical. What you can remember, build off that first and then work on the weak parts. What else? Oh, yes, Star Spangled Banner was written by a lawyer named Francis Scott Key. So as we go through, I'll try to throw in these little historical tidbits. Yeah. And John Jay, right, the authors of these Federalist Papers, basically, in a nutshell, Federalist Papers are promoting a strong central government. So I'm reading through this. I want to give you the basics here. Okay? Maintaining unity across the states. Effective enforcement of laws. Shared powers of the state and federal government, right? That's the definition of federalism. Okay, here it is. The reason that concept came about, federalism, shared powers between the federal and state government. If you remember from Monday, because I'm looking at this slide, looking at the bottom of the Federalist Papers that I have attached to it. Hamilton, Madison, and Jay. All right. Monday, I mentioned Alexander Hamilton as the first Secretary of the Treasury under George Washington. Established first national bank. There was a question on the test which said, which one of these founding fathers was not a president? Alexander Hamilton was not a president. Even though he makes his way in a $10 bill. That was actually, I was living in California after I received my master's degree. So there was a President's Day commercial. Sitting on a couch watching the commercial, and there's George Washington. Yeah, all the presidents that are on. Jackson on the 20, Grant on the 50, Franklin on 100, and they have Hamilton on the 10. Neither one of them are president. So I called up the station. Oh, well, I said, we're supposed to be educating, citizens and everything else. You have President's Day and all this. Hamilton and Franklin are never presidents. Take that down. Wouldn't you know? No, I'm serious.
No, I want to know what happened.
Yeah, the next time the commercial came out, they were gone. Yeah, gone. It was cool. Like 5 seconds. That's true story. Bill of Rights, again, first 10 amendments. I mentioned that before. Bill of Rights, first 10 amendments. Bill of Rights. If you take the Declaration of Independence, the social contract theory, English common law, you put them all together, you get the Bill of Rights. This is essentially what this slide is about. The inalienable rights, and then you go through the first 10. Limited power of the king. Now, it's very important that you get a good read on the 27 amendments. If you email me once again, I have that particular PowerPoint and the US Constitution PowerPoint. Oh, last time I promised that we would. Let me get through this part and we'll go over the electoral college process. I did mention that, didn't I? Yeah. All right, Magna Carta, we've gone through. What is influenced by the Magna Carta? The 6th Amendment, the 5th Amendment. I gave you, amendments you should focus on, 4, 5, 6, 14 are huge. 4, 5, 6, as far as legal, guaranteeing fair trials under the 6th, detailing the number of rights promised to the accused. Maybe you've watched some TV or you've watched some crime dramas where a defendant has the right and says, I'm going to take the 5th, the right not to incriminate yourself. Another big document, and it was on the test, the Mayflower Compact. 1620 is the year. Before the Pilgrims disembarked on the Mayflower, wanted to devise and agree upon how rules would be made, laws would be made, how they would be governed. The 48 adult males on board signed this compact. That all would have a voice. All the male leaders would have a voice.
Pretty depth up if you think about it.
You see, baby steps. The old Chinese proverb, right? The journey of 1,000 miles starts with one step. Basically, the rule of law under the Mayflower Compact is that laws agreed to by the people to which all residents are bound. Sorry. The citizens are subject to the same laws established by the democratically elected Congress, regardless of their position in government. Rule of law. In theory, right? And one tradition that has carried through a belief, that belief system that has carried through all from generation to generation, passed down since this time. If you look at the bottom, it is so entrenched in us as a nation, a system based on self-governing. People held the power and are responsible for governing themselves. self-governance. That theme, it trickles through generation to generation, century into century. The English Bill of Rights is very important as far as focusing on the protection of individual rights. English Bill of Rights is 1686.
Was 1686.
Yeah. Before the Declaration was announced, there's actually one very popular pamphlet that was written by an Englishman himself. This was on the test. Thomas Paine, same year the Declaration was declared, wrote a little essay known as Common Sense.
You want to read it? Have it in the library.
It is in the library. To sum it up, government only established with the consent of the governed. U.S. had the means, population, and right to govern themselves. It would make common sense. They should strive for independence. He was an Englishman who came to the colonies and fell in love with the concept. He's actually giving it, look, it makes common sense. Why should you be ruled by a pipsqueak island 3,000 miles away by a tyrannical king? You have everything you need here, all the means.
Wow.
Yeah, George, and there might be a question. George Washington forced his men to listen to the reading of two documents during the American Revolution. Which were they? Yeah. And it was Common Sense and the Declaration. Although many colonists were literate, the educational system was pretty advanced for the time. There was still, I would say, colonists above the age of 5, 60% at that time was considered pretty progressive. 60% were literate. So there was that 40% who couldn't read. So that's why Washington would have someone read documents to his soldiers. And it really was inspiring, morale. It helped to unite the colonies. So you have Common Sense and a Declaration. You also have a third. Doesn't have the effect that Common Sense and the Declaration have, of course, but the Virginia Declaration of Rights by George Mason also influenced the founding fathers and the Bill of Rights later on. Yeah, we got 3 in 1776 that are significant. You have Common Sense, Declaration of Independence, and then Virginia Declaration of Rights. This also influenced James Madison when he wrote the 8th Amendment about self-incrimination. Cruel and unusual punishment. So in the Virginia Declaration, James Madison borrows the idea for the 5th Amendment in protection from self-incrimination, as you see out here, and the 8th Amendment in cruel and unusual punishment. Speedy trials, the 6th Amendment. So James Madison had a lot to draw back on. So the point of this, the founding documents, you look at it, about civic literacy or the U.S. Constitution, is that the founding fathers didn't just pull these ideas out of nowhere. Look to the past. Anti-federalist papers, I didn't really, looking back on the two tests, there was not one question on anti-federalist papers, but I'll just in case, you never know, better safe to be sorry. Basically, the authors of the anti-federalist papers, namely Robert Yates, George Clinton, and Richard Henry Lee. Know the authors, Robert Yates, George Clinton, Richard Henry Lee. Most of you will probably know Richard Henry Lee's son, Robert E. Lee, future Confederate general. Okay, so anti-federalists. Let's use our common sense and we're prepared. So they would be against what Alexander Hamilton and the Federalists. They're opposed to the ratification of the Constitution. They're opposed against a central government. That's too strong. So Robert Yates, George Clinton, Richard Henry Lee are against the ideas of Alexander Hamilton, John Jay, and at first, James Madison. They think the Constitution gives the government too much power. However, the good thing about the anti-federalist papers and the good thing about Robert Yates, George Clinton, and Richard Henry Lee, which should be agreed upon, is that the only way the Constitution could be ratified is to incorporate a Bill of Rights, specifically delineating the rights of the American people. That's big, right there. That's it. Anti-federalist papers, Robert Yates, Richard Henry Lee, George Clinton. You want this thing to be ratified, you need to guarantee, specifically written down, nothing can be assumed. That tactic actually worked. Look at that right there. And that compromise between the anti-federalists and federalists will be a tradition of compromising, which today doesn't exist, but it's given a country that, the latitude to grow and live to be 250 years. This is the key. Think about it. The very first time, the Constitution looks good, creates three branches, separates powers, checks each other. No one's more powerful than the other. But wait a minute, something's missing. What about the individual rights of citizens? No, that's just no, don't worry, that's assumed. No, it's not. You want this passed, you want this to get ratified, you want it to become the law of the land, and you better add a specific list of individual citizen rights. That's it. That's your very first. And the Federalists said, okay.
This ain't about assume.
And right there. So you have to give anti-federalists credit. But that the fact that the Federalists and the anti-federalists came together and the Constitution did become law, if it's followed like it's supposed to be, it's a genius piece of work. It really is. So here it is, the influence of the anti-federalist papers. I thought was making a test. Like I said, to be transparent and honest here, and I have a good memory, I don't remember one question on the anti-federalist papers. If there was, it would be that, look at the bottom of the slide, where it says that the influence of the anti-federalist papers, and I just explained it, it forced the Federalists to promise the addition of the Bill of Rights. And it's there. The reason it's there is because of the work the anti-federalists did. I think we're getting close to our final. Yeah. All right. I'm just gonna, I'm coming back to this slide. Don't worry. I just want a 1, 2, 4,
You want to do the
5,
other?
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 18, 19, 20, 21, 22, 23, 24, 25, 26. Okay.
Did you do the electoral?
No. All right, the electoral college, let me get back to. I'm going to explain the electoral college process. It is also in my US Constitution PowerPoint. Then we'll go over these landmark cases. Now, this is basically plain and simple. It's really pretty much up to you to go through the Supreme Court cases. There's a case summary and a legacy of each decision. What I'll try to do is to explain them briefly and maybe assist you in categorizing them, putting them in different categories so it'll help you memorize them better. All right, the Electoral College. Okay, each state. First of all, no, let's go back further than that. Under Article 2 of the US Constitution, the idea of electing an executive. There was an argument about should there be a general election? Should it be decided by popular vote? Should uneducated people, I mean, they had an argument, knockdown, drag out about who should be able to vote, how this process is going to work. And so it kind of, our founding fathers were a bit elitist, most part. So they devised a scheme that would allow each state, and every state, all 50 states have a different process. Each state would devise a process or devise a process for having an electoral college, a group of basically, you could put this in parentheses, professional voters. The state of Florida has its own. Now, each state's the number of House members of the House of Representatives, the number of the members of the House of Representatives. In the case of Florida, there are 28 now. In Florida, plus the 2 senators give you the electoral count. So the state of Florida has 30 now. 28 plus 2 equals 30. That's how they came up with the scheme. The idea behind it is we can't use popular vote. Why? Well, candidate, let's say I was a candidate, I want to run for president. And it's based on popular vote alone, majority. Okay. I'm just going to campaign in California, New York, Texas, Florida, Pennsylvania, Virginia. That's it. And you know what? If I just did that, I could win. That leaves the rest, that leaves the rest of the United States out. So yeah, you're thinking, yeah, we'll vote majority rule, but wait a minute. What about people in Montana, Wyoming, Alaska, Hawaii, Delaware? I will literally campaign in 8 states and I could win by popular vote. Now, take Florida. Okay? So if you're wondering out there, or anybody's wondering, why don't we do it that way? That's why. So you have a candidate that can just campaign, that somebody you never even heard of can be president of the United States. So this way it gives each state a voice. Now, how does it work? Okay, why should your vote does count? In every election except for 5 in US history. Okay. On election day, we cast our votes. The votes are counted in the state, in Tallahassee. Eventually, the totals get there, right? Based on percentage of votes. Electors from each participating party will be chosen. Electors representing each political party. In this case, Republican or Democrat are chosen. For instance, I don't know the exact numbers, but I'm just providing an example. In 2024, Donald Trump received 3 million votes in Florida, right? I don't know. I'm just using an example. So he gets 3 million. And Kamala Harris gets 2 million. Three to two. Not the greatest math guy, but once again, give you an example. Based on those numbers, the 30 electors will be chosen. Now, because Trump has 3 million, he has a 3 to 2 edge. There will be 20 electors that are Republican chosen to vote. So 20 Republican electors. Which leaves Kamala with how many? 10. 20 to 10, right? 30 votes. Now, 95% of the time, these electors will vote along party lines. So Trump wins the state of Florida and he gets all 30. This is a winner take all state. A winner take all state. 20 to 10 Trump, he gets all 30. Now, in 5 elections in US history, electors can vote with their own conscience. Like I said, 95% of the time, they're gonna go along party lines. This is their formula. Okay? But what if this same formula, Trump wins 3-2, 3 million to 2 million, he gets 20 to 10. But there's a possibility that 10 of those Republicans that are chosen as electors say, I know he's with our party, but don't like him as a candidate. Okay, 10 of them basically defect and vote for Kamala. Even though Trump wins the popular vote in Florida, Kamala Harris takes state because 10 Republicans joined her. She'll get the 20, Trump will get the 10. And that's how 5 times that happened. That's the only glitch, really. And considering all the elections in US history, it's really not bad. For the most part, that works. There are 2 states, this could be, and I remember this question. There are 2 states in the electoral process that are not winner take all. Question on the civics literacy test could be, which states are not winner take all according to the electoral process? 2, Nebraska and Maine. Whatever elector votes you get, those states you keep. So let's say Trump and Kamala Harris same numbers. If it's Nebraska or Maine, Trump gets 20, Kamala gets 10, and they keep it that way. State of Florida, winner take all. Has everybody got that? Only 2 out of 50. Sure.
The number of House representatives plus the 2 senators, is that only for Florida? Or
Every state. That process is the same, every state. But they're gonna be different based on population. Like, and for instance, the formula is the same, but have that, Steve, look up an electoral map and you'll see how many votes still exist. We're still, if the map they look up, might still have Florida at 29, so we're in the process of moving to that 28th district. So you might see 29 or 27 districts plus 2 senators. It's supposed to go to 28 plus 2. All right. Supreme Court cases, landmark cases, and then landmark legislation. Marbury versus Madison, review it, 1803. It's the first major Supreme Court decision. It establishes judicial review. Judicial review. It basically gives the Supreme Court the power to declare legislation unconstitutional or executive orders unconstitutional. Oh, categories. We're going to start with 19th century decisions. Put 19th century decisions, Marbury versus Madison. Now, I'm giving you a way. You don't have to follow this. You can develop your own way to categorize Supreme Court decisions. This kind of breaks it up, so it helps you remember. So Marbury versus Madison, judicial review. McCulloch versus Maryland, 1819. There's a case summary. But basically, what McCulloch versus Maryland does is gives Congress the power to establish a national bank. It also establishes the supremacy of the federal government. And the Constitution as the supreme law of the land. So according to McCullough versus Maryland, if there's any dispute over who has the power, federal government supersedes state. Yeah, they have, in federalism, they share powers, but if there's, of course, there's gonna be a dispute over something. And it could be a dispute over anything. If there is a dispute over anything, federal government supersedes, Constitution's law of the land, that's it. If you look at McCullough versus Maryland, the decision for the 11 states to secede from the Union and start the Civil War is unconstitutional. These Civil War buffs. This is huge. Dred Scott, this was on both tests. Review this case. 1857. Dred Scott was a slave that was, from Missouri, whose owner had brought him to several free states. Now, according to Missouri, he has the right, unbelievably, I didn't even realize, unbelievable that the state of Missouri, a slave state, would have a law in the book saying that anyone, whether they're slave or not, can sue. So he took that upon himself. Because he was brought to a free state, which meant he was supposed to be free. Even when you bring him back. So his owner took him to a free state for a period of time. Then he came back. Then took him to a free state again. Then he came back. Well, he decides to sue in 1854. Unbelievably, appeals it to the Supreme Court. This is a make or break decision. This could have avoided a civil war. This is huge. And the Supreme Court fumbled the football. They dropped it. They struck out. They missed the ball, the free throw to win the game. In a 7-2 decision, Roger Taney took a coward's way out and ruled that African Americans held no right to citizenship. Therefore, they couldn't sue. And under the Fifth Amendment, Roger Taney explained that property rights are protected by the Constitution. Therefore, since slaves are property, Congress can't take them away. This is a major setback. Because the interesting thing is, and while we're here, and we didn't get to it in the US Constitution, the 3/5 compromise. When you're reviewing the US Constitution and I send you the PowerPoint on the Constitution, there's the 3/5 compromise over the issue of slavery. All right. Just to sum it up, make a long story short. Vote counting and representation in Congress was an argument between the Southern slave-owning plantation owners and those members at the Constitutional Convention who wanted to deal with slavery and end it or abolish it. Well, they all agreed that they couldn't establish a permanent United States or a US Constitution because basically the slave owners wanted to say, look, we're going to take our ball and go home and you can forget this. We're not going to stay. All right, we'll deal with it later. What's the agreement? But how are we counting population? So not only they're going to give in to the slave owners to stay there, write a constitution and allow slavery, number one. Then they got to give concession to the slave owners. Well, all right. What we'll do is we'll count 3 out of 5 of your slaves. So the 3/5 compromise. It's not, people mistakenly think it's 3/5 of the person. No. Every 3 out of 5 slaves will be counted towards population, which will give South Carolina, North Carolina, Virginia, Tennessee, Arkansas, Alabama, Mississippi, Texas, Louisiana, Georgia, Florida. Extra representatives that can write legislation and maintain their interests in Congress. So 3/5 compromise. Okay, so it's 3 out of 5 counted towards Southern slaveholding populations in order to give them more representatives in Congress, in the House. The reason I remembered this is because my argument with Roger Taney here, he says that slaves are property. They can't sue. But yet they were good enough to be counted in votes and representation. That's what Dred Scott's lawyer never didn't use that defense. And then the Supreme Court, which probably in this 19th century Supreme Court is, got to rank it up there as the worst, the latter part. Then they come back, Plessy versus Ferguson was definitely on the test. Before Plessy versus Ferguson, many southern states after Reconstruction were passing what were called Jim Crow laws. Jim Crow. Jim Crow is a reference to legal segregation after Reconstruction through the 1960s. Jim Crow,
1860s.
1960s.
Oh,
But the case reaches the Supreme Court. Homer Plessy, who refused to give up a seat in Louisiana on a train. So before Rosa Parks, there was Homer Plessy. All the Supreme Court rules, well, as long as the facilities are equal, it's constitutional. So therefore, what Plessy versus Ferguson does was legitimize Jim Crow legislation. So these segregation laws will force African Americans in the South into second-class citizenship. So far, with 4, there's a good chance you're going to see them. Barber versus Madison, McCullough, Maryland, Dred Scott, Stanford, Plessy, Ferguson. Schneck into the 20th century decision. This is also, you could put this under world wars. Okay, because Schneck versus the United States has to do with World War I. Then when we get to Korematsu versus the United States, that's the one George Takei, Amanda, your Star Trek character, actor. He was part of Korematsu versus the United States. All right, in Schneck versus the United States, this is after World War I. Charles was a socialist, passed out leaflets to resist the draft. He was arrested. Oliver Wendell Holmes argued the First Amendment does not protect speech that poses a clear and present danger. Some speech cannot be protected when it risks national security or public safety. So it has to do with the scope of free speech. There's also a little trick I like to use. I can put like alliteration together, or for instance, scope starts with an S, and so does Schneck. So if I was studying and putting it together myself, all right, Schneck scope of speech. Okay, it has to do with freedom of speech. Just a little trick. This limits freedom of speech, okay? So, you have a lot of citizens say, that goes against my freedom of speech, but for the most part, they're right, but there is an exception. if you challenge or risk national security or public safety, and the Ku Klux Klan can get a permit as long as they peacefully assemble. They can wear their robes and march down the street and shout all over, but they come to your house and burn a cross and you're on, that's not public safety anymore, and therefore that does not operate under freedom of speech. Korematsu. World War II. Tragedy of the Japanese Americans and their denial of civil liberties, forcing many into internment camps. The Supreme Court ruled that the camps were legal. Tricky one, because the US court actually tried to fix it. They knew it was wrong. Franklin Roosevelt, one of my favorite presidents, but this is not something I would have agreed with him. Even he had second thoughts and allowed asked young Japanese Americans to fight during World War II. 30,000 of them did. It tells you what kind of character those guys had. That's incredible. But Supreme Court adjusted the decision saying only if enemies of the United States, for instance, there were Italian Americans, German Americans, and Japanese Americans. World War II, the United States was planning on 3. And the question is, why aren't the Italian Americans and the German Americans being interned? Why just the Japanese? That's when the kind of, oh, wait, yeah, you have a point there. Only those who are enemies of the United States during the war and show their disloyalty should be put in a camp, like you catch a spy. And a little tricky, but I don't remember the question being posed that way. It was mainly what was the legacy or what Korematsu versus the United States has to do with. What does it have to do? That was a straightforward question. It has to do with the internment of Japanese Americans during World War II. All right, Brown versus Board, you can put this one in the bank. That's huge. Brown versus Board overturns Plessy versus Ferguson. You always want to put Plessy versus Ferguson with Brown versus Board. Okay, because Plessy versus Ferguson says separate but equal is constitutional. But Brown versus Board says, no, it's not. It's unconstitutional. It's also one of the first cases where the Supreme Court overturned a previous decision. This Supreme Court, Earl Warren, this Supreme Court in the 50s and 60s, I wish they could be alive today. I wish they could be on the Supreme Court right now. 9-0 on this decision. This Supreme Court really put together and made decisions not only based on legality, but morality in a sense. What was right? What was right? Yeah. This decision was 9-0, not one dissenting vote. So a little girl named Linda Brown wants to go to school in Kansas, right down the street. She's gay. She's black. She'd have to take a bus and go almost 10 miles. But she went to school, she could go to, she walked to pack her lunch, walk out the door and go down the street. Historical facts. Thurgood Marshall was the lawyer who argued for Linda Brown. Thurgood Marshall, who will later be the first black Supreme Court Chief Justice, was her lawyer.
That's David lawyer.
Heck of a lawyer, right? Future Chief Justice, yeah, he's the man. The evidence he brought was unbelievable too. Well, part of his argument was throwing down the separate but equal. Right? And so the NAACP he worked for at the time, so he traveled all over South, he got all these materials, he got books from high school, black high schools, textbooks. And he got books from white high schools, he got photographs from white high school football fields versus black high school football, all of it. And he showed it to the Supreme Court, basically saying, look, separate but equal, huh? Well, the typical textbook in high school, black high schools, senior class algebra was an 8th grade mathematics book. Teachers basically have to teach the textbooks for them. He argued that the state funds in Jim Crow states, state legislatures were all white. They were only going to give the tax money to the white schools. They were getting the new textbooks. They were getting the new football equipment. They were getting the new gyms. They were getting the swimming pools in the gymnasium. He proved that. And that's why it's a 9-0 decision. I mean, you have to be, I'm sorry to say, an idiot not to look at that evidence and say there's no way it's equal. Incredible. Matt versus Ohio. Illegal search and seizure. So Matt versus Ohio is more of, what would you categorize? Depending on what you want to categorize. What's that? A violation of an amendment. Yeah, you can do it that way. Like I said, you want to develop your own system, whatever works for you. But Matt versus Ohio is a challenge to the 4th Amendment. Right? So Matt, Ohio, 4th Amendment, illegal search and seizure. Okay, Baker versus Carr. Secretary of State of Tennessee, Joe Carr, thinks that the ability of the federal courts to hear cases involving, redistricting. We're going through that right now. It's called gerrymandering. Charles Baker of Tennessee sues state officials arguing that the system used to establish congressional districts was outdated and unfair. It favored rural areas, not urban areas. So this has to do with, just put Baker versus Carr, gerrymandering. And ultimately, in the decision, federal courts have the right to intervene in cases that pertain to a violation of constitutional rights, meaning that all areas need to be represented equally. Basically, Baker versus Carr, equal representation in districts for voting, congressional district. I didn't see a question on Baker versus Carr. That's one of the complicated Supreme Court decisions. But still, I mean, we're dealing with a gerrymandering issue for the upcoming midterm elections and redistricting and how fair or unfair it is. Engel versus Vitale, definitely saw this. Okay, this has to do with prayer in public schools. Prayer in public schools. Now, I'm a product of private, middle and private Catholic high school, so we started our day. You didn't pray, the nuns would have something to say. And not always something to say, they might bring a ruler along with them. But here it is, this is why there is no prayer in public schools, because it's a violation of the First Amendment.
Yeah, Texas. That's a command. Which one with the Texas too with the bison?
Louisiana also has the 10 Commandments on the board, And it became like a mandatory thing for all schools in Louisiana.
No, once because she's Bible lit now, I can't remember what she found.
Well, that's still a violation of the First Amendment,
Oh, yeah,
so
was able to live with
unless that school wants to, they can establish private schools.
it. It was staying away,
Private
public
schools
schools
will
has
do
to
it.
teach literature.
But according to, anyways, that's good. That's a good way to help you remember. Angle Vitale Parent Public Schools, because it's an issue in certain states
Today.
today. At 1962, the Supreme Court, which I believe, I thought that the United States was more traditional and conservative in rural areas in 1962. This was groundbreaking in 62, you know. Gideon Wainwright is another classic. The right to an attorney. Sixth Amendment, Gideon Wainwright. Guaranteed an attorney for individuals adjudicated in state courts. Clarence Gideon was arrested for breaking and entering. Gideon appears without an attorney, citing financial inability, can't afford one. This will eventually be included in your Miranda rights, right? Can't afford an attorney, one will be provided. And the state of Florida denied him that right because they only provided an attorney for capital murder cases, not felony breaking and entering. Gideon represents himself, found guilty, petitioned Supreme Court, arguing he was violated under the Sixth Amendment. This is classic, one of the great cases. There it is. I just mentioned it. All right, so you want to put, as far as violating the right, you put Engel versus Vitale, Gideon Wainwright, Miranda, Arizona. Especially Gideon Wainwright and Miranda, as they follow one another.
That was also 6.
Yeah. Make sure, as far as case summary, the details, right? Clarence Gideon and Ernesto Miranda, Arizona. Arrested for kidnapping and assault. Upon questioning, without being informed of his rights, Miranda confessed. The state used this confession as evidence. He's convicted and sentenced. Case is appealed. Supreme Court ruled in favor of Miranda. A suspect might be directly informed of his rights prior to custodial interrogation. Which, see, even if he is guilty, because police used to use what's called the third degree in interrogation tactics. The first, this is old school, first degree is being polite, yeah. You know, what were you doing, this, that. The second degree is to offer a deal, and the third degree is physical violence. Either you tell me the truth or I'm gonna beat the you know what out of you. So that's if you ever heard the third degree. So confessions under those circumstances, even an innocent person would finally get beaten or held long enough that they say, yeah. So the court wants to prevent that from happening.
And that's what a lot of people who were accused of witchcraft. They
Right.
waited until they said, yeah.
I did it. So that's why it's important to have rights read beforehand. And during interrogations, once a suspect can, when I want a lawyer, that interrogation is supposed to stop at that point. Okay, Tinker versus Des Moines. These are student protests. This is another First Amendment. And these are students who wanted to protest the Vietnam War in 1969 but wearing black armbands. Supreme Court rules in favor of the students. Look at the decision, the Warren Court, Chief Justice Warren, right? That's what, from Brown versus Board of Education, Engel Vitale, Baker Carr, Gideon Wainwright, Miranda, Arizona, Tinker, Des Moines. Some serious historical decisions made here to protect the rights of citizens. You know, you're gonna, and then probably one of the most controversial. So, follow those, that Brown versus Board, the Baker Carr, the gerrymandering, you know, Gideon Wainwright, Miranda Arizona, due process violation of, so far we've had First, Fourth, Fifth, and Sixth Amendment rights. 1971, New York Times versus United States. Daniel Ellsberg was a military analyst. This was on the test. Basically the question was, what was the New York Times United States Supreme Court case of Daniel Ellsberg based on? Is the release of the Pentagon Papers. The Pentagon. They attempted to publish a report by the Defense Department that detailed American involvement in Vietnam and the consequences of continued involvement. Really, the leakage of the Pentagon Papers and this information is really when protesting against Vietnam turned, into fifth gear. Kick it up. Because in the Pentagon Papers, basically the military was counting a body count, and basically the advice of intelligence was to say that the United States should get out of Vietnam. And the Nixon administration did not want that information. This is the key. It's quite interesting because this might be on the test, and it was on one of them, so I'm not sure. But if it will be, but this would lead to increase in college campus. Kids your age, for the most part, your age has students in college who took it to the streets and protested. Would be an incident at Kent State University where students would be shot, killed. And this was after this Supreme Court case. But the Supreme Court, once again, following, I'm telling you, the Supreme Court, it makes you proud. They had a Supreme Court. It ruled against the President of the United States. He wanted the idea, the reason the government sued here. He thought that this leaked military, now he wants to use national security for everything. And that you hear that a lot. You watch movies or you watch national security for national security reasons, for national security. National security reasons. Like we had another fatal shooting in Maine.
And he was not the intended target.
Like the Keystone Cops that gave him guns, for national security purposes, but this time Supreme Court said crime restraint was unconstitutional unless the government could prove that the material in question would lead to immediate and direct harm. This is a group of papers with intelligence information saying the United States should get out of Vietnam. How does that threaten national security? So, Supreme Court gets it right. 1972, a year later, Wisconsin versus Yoder. This has to do with education again. First Amendment. The Amish community argued that the fine and compulsory education laws violated their religious beliefs. Supreme Court ruled in favor of the families. Wisconsin compulsory education law violated the free exercise clause of the First Amendment. So the state of Wisconsin cannot force the Amish to attend high school, which conflicted with their religion. Basically, you want to know where homeschooling started? Probably here. The state of Wisconsin basically gave the Amish permission to educate their own children. As long as you abide by the state sanction, you can educate them at home. Wisconsin, Yoder, homeschool education. Oh, most controversial Supreme Court case, you gotta put it up there with Dred Scott, Brown versus Ford, Plessy versus Ferguson, Roe versus Wade. Roe is Norma McCorvey. At the time, she preferred her name be left out, so instead of John Doe, she became Jane Roe. Is John Doe for an alias for unidentified bodies, John Doe? It's Jane Roe. But eventually her name came out. It's Norma McCorvey.
No, I heard that like John Doe and Jane Doe are just like the same.
On this case, they use Jane Roe.
Okay.
The case is that, Texas. Unmarried pregnant woman assigned the name Jane Roe to protect her identity. Arguments that the Texas anti-abortion law was unconstitutionally vague and not consistent with the first, fourth, fifth, ninth, and 14th. Texas court ruled in favor of Roe, but did not rule that Texas had to discontinue the enforcement of its anti-abortion. Roe eventually appeals to the Supreme Court, and the Supreme Court struck down Texas abortion laws. The case overturned most state laws prohibiting abortion. But in 2022, the Supreme Court reversed Roe versus Wade, finding no constitutional basis for requiring the states to permit abortion, returning the authority to the states to decide. So that's where we stand now. Highly controversial, still is, very divisive, very polarizing. In 1973, the Supreme Court strike down abortion laws. Oh, U.S. versus Nixon, Watergate. This one's pretty easy. Nixon administration attempted to spy on political opponents. You hear Watergate, and every other scandal has the name Gate attached to it now, like Spygate and Deflategate, this gate, that gate. But the original, the only one that makes any sense is Watergate, which is the name of a hotel with a Democratic National Headquarters. And Nixon gave the okay. He knew later on was revealed in tapes. He authorized a break-in so that he could get dirt on possible Democratic candidates for the 1972 election, which was completely unnecessary. He won in a landslide anyways, but eventually, even as a kid, for 2 years, every night, 6 o'clock news, Watergate, every night. Yeah. So led to Nixon's resignation because Supreme Court called for Nixon to turn over the tapes. And rather than be disgraced and convicted, he definitely would have been impeached and removed. Before that, he resigns. So there's a summary about the United States versus Nixon. Supreme Court orders Nixon to turn over evidence, tapes that he had, which would incriminate him because he was on the tapes giving the okay, knowing that the Democratic National Headquarters would be broken into. And all of this leads to his resignation. Regents of the University of California versus fake and banned quota systems and college admission process. So we have another school one if you're creating categories here. This has to do with schools.
Civil rights,
What?
civil rights.
Yes, okay, you put it under civil rights. Legacy of Regents of the University of California versus Fake. Supreme Court ruled that race could be used as only race could be used as one factor by college admissions boards, but quotas are ruled to be discriminatory. I have to decipher that one. But basically has to, it's provided and provided a complex legal standard for affirmative action. It's not gonna test, I'm not gonna ask you to explain. You know, you have to be a lawyer to understand the complexities of this case and what that means. College admissions boards, what quotas are ruled to be discriminatory. Basically, Regents, University of California, laid out the legal standard for affirmative action. Laid out the legal standard for affirmative action. Hazelwood, First Amendment speech rights of students enrolled in public schools. 1983, a group of students from Hazelwood School submitted a paper for approval. The principal finds 2 articles inappropriate. Case decision. This time, the Supreme Court ruled in favor of the school. School has the right to censor student speech that does not align with its educational mission. Okay. I might compare this to the Supreme Court decision on the protest in the Vietnam War, but you know, studying the Vietnam War is part of school curriculum. Texas versus Johnson. Texas, 1989. I remember this. I was in college. Man in Texas, Johnson, Gregory Lee burned the American flag outside the Republican National Convention. States had laws against flag desecration. Johnson was convicted and sentenced, plus a $2,000 fine. The Supreme Court ruled in favor of Johnson. Burning the flag is a form of symbolic speech protected by the First Amendment. The government cannot ban an expression for the sole purpose that others find the act to be offensive. Although it might not be the most popular decision to make, burning the flag is protected under your First Amendment. Here's another Sean Reno review this. And we're kind of getting close to, I want to use the rest of the time wisely. So you want to just review the rest of these Supreme Court cases. Not all of them are going to be on there. But just review them, focus on the big ones that I mentioned, like Marbury versus Madison, Dred Scott, Plessy versus Ferguson, and have real effect and a legacy in American history. Free speech in violation of your First and your Fourth, your Fifth, Sixth. They have it all here for you. Bush and Gore, that was on the test, okay? See, no, just Bush and Gore. This decided the 2000 election for George Bush and the state of Florida. Because of the consistency in counting and how long the procedure was going to be. I remember, it could take months to decide. Basically, the Supreme Court also ruled, you're leaving the country in limbo. The votes were counted in favor of Bush. That's it. We have to have a president. And that was it. There wasn't enough time. That was on the test. Bush Gore, 2000. While you're here, while you're students, I just want to take 1 minute. The great thing about this, the whole question of the 2020 election and rigged elections and all of that, January 6th, the rioting, everything else. Let me tell you what Al Gore did.
I remember that.
Okay, Al Gore was vice president under Bill Clinton. He lost because of this. A county in Florida and the Supreme Court sided with George Bush. Did he start a riot? Nope. He was vice president. Mind you, he was the vice president. He had to certify the votes in January. I'll never forget it because he stood there, said all votes have been certified. George Bush, his opponent, I mean, this guy, talk about class and humility. George Bush won the election. And even some of the members of Congress were shouting, no, no. Bush got mad, he come, but he said, no, no, no. He won. I lost. He's the president of the United States. And then the whole chamber. Let that be an example of what we should be. What a class act. What a man. Took it like a man. I lost. He's the president. Walked out. That's it. That's it. What a great moment. And this should be taught in every class. How to handle defeat. Even with controversy. And to keep your country from splitting. Never forget that as long as that lives. Okay. Let's get to, all right, landmark legislation. Great compromise. We covered, it's also known as the Connecticut Compromise. We covered this in the Constitution. Article 1, the legislative branch would be a combination of the House of Representatives based on population and the Senate equal representation. Roger Sherman, all of that's there. You already have this. Another landmark is the Compromise of 1850 written by Henry Clay. California comes in as a free state. And there will be a new fugitive slave act that will strengthen the returning of slaves, runaway slaves back to their masters. If any of you have ever seen the movie 12 Years a Slave, this is because that character, Solomon Winthrop, was a casualty of the new fugitive slave law. The Kansas-Nebraska Act, written by Stephen Douglas. The new territories of Kansas and Nebraska the issue of slavery would be decided by popular sovereignty. The Kansas-Nebraska Act led to violence that basically foreshadowed the Civil War. So what you want to know, Kansas-Nebraska Act leads to Bleeding Kansas. If you read down through the slide, you'll see Bleeding Kansas, the violence between pro-slavery and anti-slavery resulted in a dress rehearsal for a future Civil War. The Homestead Act led to greater westward expansion. Signed during the Civil War. It gave 160 acres of free land for a $10 deposit. That was on the test. Now remember the Homestead Act, 1862. Legislation that gave settlers 160 free acres of land for a $10 fee has helped to expand and encourage westward expansion. It also was promoted and advertised in Europe. This led to many Irish and German immigrants coming to the United States. The first piece of legislation, this could be on the test itself, to eliminate corruption on the federal level. Corruption in federal government is the Pendleton Act, which requires employment be based on merit. Know what the spoil system is. It's underneath the Pendleton Act, okay? That could be on the test. And it's if we think corruption is bad now, The leaders and business leaders and political leaders of the late 19th century could come here and teach us a lesson on corruption. But here's an attempt of the federal government to say, not at this level. You want a job? You gotta take, civil service test. It's gonna be based on merit. Usually, the spoil system is rewarding your supporters. For rewarding your supporters for being loyal or for donating money to your campaign, for working on your campaign, and you reward them even if they're not qualified. Bless you. Thanks. It's like, making somebody secretary of the treasury who's never had experience in finance, banking, or any other, economic endeavor. It thinks, you know what? You run a landscaping company and you donated, $12,000 to me. I'm gonna make you secretary of the treasury. Yeah. No offense against landscaping people. You get the point I'm trying to make. It was unfair. People who are unqualified because they're loyal or they gave money. This is based on merit. Interstate Commerce Act was mentioned on the test. Very important because it kind of took away power from the railroad, the powerful railroad owners, industrial people like Andrew Carnegie, J.P. Morgan. They were very powerful. They would discriminate on their rates to force out competition. And the Interstate Commerce Act is the first government attempt to regulate the railroad industry. Can't do that. It's unfair. It's unethical. Railroad railroad rates need to be fair, reasonable. They need to publicize their rates to ensure fairness. I mean, all the provisions of the act, to protect businesses and passengers. Alien and sedition acts are being questioned as we speak. These were repealed. There are some leaders in government today who wish to revive and revise the Alien and Sedition Act. President John Adams. This led to if you want to take down a note, it's because of the Alien and Sedition Acts that the Federalist Party died. George Washington and John Adams were the only Federalist presidents. Because John Adams ruined it, he took away First Amendment rights. Not one of his prouder moments. He was such a contributor, John Adams, to the Massachusetts Constitution, the second president of the United States, vice president. But John Adams couldn't take criticism, couldn't take debate. So certain papers were writing, criticisms, and he passed this illegal to speak hostile against the existing government. Are you kidding? And this act allowed the president to deport anyone in the United States who was not a citizen and was suspected of treason. Sound familiar?
Trump and the ICE thing.
I didn't say that out loud. That's But yes, a Civil Rights Act of 1871. Under Ulysses S. Grant, as my admiration for this, these acts broke the first Ku Klux Klan, broke them down. Had many of their members and leaders arrested, the very first Ku Klux Klan. Although they would make, they would die and be reborn, die and be reborn, die and be reborn. Now they're in their fifth life today as we speak.
Like a contract.
Fair employment, Bowling versus Sharp, just review. Okay. These two, Civil Rights Act, 1964, this is getting under attack by the present administration. There's a march being organized by Reverend Al Sharpton. Voting rights for African Americans in Georgia are being threatened. Loving versus Virginia, the interracial marriage was against the law. You can be arrested and go to jail in Virginia in 1967. Mildred Jeter and Richard Loving.
There's a movie.
Yeah, that's a good movie too. Supreme Court found the Virginia law prohibited interracial marriage unconstitutional and overturned the couple's conviction. Good story. All right, you have. All right, add this. It's Civil Rights Act of 1964. You also have the Voting Rights Act of 1965. Where is that? Oops, not there. Sorry. And the Voting Rights Act, 1965. Look that up. Voting Rights Act, basically, you cannot discriminate or cannot discriminate, institute poll taxes or literacy tests. Any voters who are citizens of the United States.
That's right.
Totally, eliminated. There used to be especially for African Americans, they had to pay poll taxes, take literacy tests before they could get the right to vote. So no discriminating. The Civil Rights Act of 1968, also known as the Fair Housing Act, that could be right there. That's a good test question. That pretty much, this is the last slide. We wish you all the best of luck. Glad you could attend the last two sessions. If you email me either tonight or at the latest tomorrow morning, I will send all material that had the Constitution and the amendments. Rights, and Amanda's going to get the links sent to both sessions. If you happen to miss Monday, or you know someone whose Monday is not here today, whatever, we'll have both links available, and it would really be helpful if after you take the test and when all of you pass, that you could give us feedback as far as what kind of questions you saw, anything that will help us in the future. We're trying to build in these study sessions. What would make it better? What would make us better based on your experience? Good luck to all of you, and have a great day and a good weekend.
All right.
Thank you.
Gosh, like.